Let's be real. Navigating the legal system, especially family court, can feel like you've been dropped into a maze with no map and no instructions. It's confusing, it's stressful, and it is so easy to feel like you have zero control. But what if you had a playbook, a guide to the most important tools you can use to make your voice heard? Well, that's exactly what we're going to break down today. You know that feeling of being completely powerless, just waiting for a judge to decide your future? If you've ever felt that way, you are definitely not alone. It's such a common feeling when you're dealing with things like child support or visitation. But the system isn't actually designed for you to be a passive observer. There are tools, real tools you can use to actively participate and ask the court for what you need. And the single most important tool in this entire process, it's something called emotion. Seriously, understanding what it is, and more importantly, how to use it, is the very first step toward taking back some control in your case. So, what exactly is a motion? At its core, it's just a formal written request. Think of it as the official way to talk to the court. I mean, you can't just call up a judge or shoot him an email, right? If you need the judge to do something, change an order, enforce an order, or make any kind of ruling, you have to file a motion. It is the language the court understands. Okay, the best way to think about this is like having a legal toolkit. You've got all these different motions, and each one is a specific tool designed for a specific job. And just like you wouldn't use a hammer to turn a screw, you've got to use the right motion for the right legal problem. The whole key is knowing which tool to pull out of the bag. And wow, just take a look at this list from the playbook. I mean, we're talking about dozens of different motions, each for a specific situation. It's a lot to take in, and seeing a list like this can feel pretty intimidating, and that's totally understandable. It really puts the complexity of the whole system into perspective. But hey, don't worry, we're not going to dissect every single one of these. For this explainer, we're going to keep it simple. We're going to focus on 3 very common problems and the specific tools, the specific motions you can use to solve them. All right, let's tackle our first problem. And trust me, this one is a classic. You have a court-ordered visitation schedule, a parenting plan, but the other parent just isn't following it. Maybe they're always late for pickups, or worse, they're blocking you from seeing your child altogether. What do you do? The tool for this exact job is a motion for parenting time enforcement. The purpose is right there in the name, enforcement. And look, the key here is you're not asking to change the schedule. You are formally asking the court to step in and force the other parent to follow the order that's already in place. Okay, scenario number 2. Your financial situation has completely changed. Maybe you lost your job or took a big pay cut. That child support order from a year ago is now basically impossible for you to pay. And you can't just stop paying. That's a recipe for disaster. The tool you need here is a motion to modify child support. This is your formal way of asking the court to take another look at the numbers. And the magic words the court is listening for? A material change in circumstances. That's just a fancy legal way of saying something big and long-term has changed, like losing a job that makes the old order unfair or just plain unworkable. And our third problem, which is a really tough one. Your driver's license has been suspended because you've fallen behind on child support. States do this a lot to enforce payments, but it can create a terrible cycle, right? How are you supposed to get to work to earn the money to pay support if you can't even legally drive? For this, you're looking at a motion to reinstate license. But, and this is a big but, it's not a magic wand. As the playbook points out, you usually have to take some steps first to qualify, like making a good faith payment or getting on a payment plan. Once you've done that, this motion is how you officially ask the judge to lift that suspension. Okay, so you figured out the problem. You've picked the right tool from your toolkit for the job. That is a huge step. But now what? How do you actually use it? Let's get into the basic mechanics of how you actually file one of these things. Now, before we even get into the steps, I need you to really hear this quote from the playbook. This is a non-negotiable, absolutely critical part of the process. If you don't follow the rules for notifying the other person in your case, a process called service, the judge can just throw your motion out completely. All that hard work for nothing. So the procedure isn't a suggestion, it is a requirement. The whole thing really boils down to 3 core steps. Think of it like this: file, serve, proof. First, you file the motion papers with the court clerk. Second, you serve a copy to the other party. This means officially delivering it in a way the court recognizes. You can't just, hand it to them at drop-off. And third, and seriously, this is the step so many people forget, you have to prove to the court that you did step 2 by filing another document, usually called a proof of service. And this is what that proof looks like. It's basically your receipt for the court. It's a simple form, but by signing it, you are swearing that you followed the rules and officially notified the other party. Without this receipt, as far as the court is concerned, it never happened, and your case can't move forward. All right, so you've done it. You filed a motion, you filed your proof of service, you've taken action. That's huge. The big question now is, what happens next? And this is where managing your expectations becomes so important. So let's talk timeline, because this is where the waiting game really begins. The playbook is super clear on this. It can take weeks or even months to get a hearing date. The reality is the court system just doesn't move fast. The playbook has a great tip here. If it's been over 60 days and you've heard nothing but crickets, it's totally okay to politely call the clerk's office for an update. Eventually, you'll either get your day in court or the judge will make a decision based on your paperwork. Patience is not optional here. Okay, let's boil all this down to the key takeaways you really need to remember. Number 1, filing a motion is a request, not a guarantee. The judge can still say no. Number 2, the wheels of justice turn slowly. Be prepared to wait. 3, procedure is everything, especially serving the other party the right way. And finally, a pro tip: keep copies, physical or digital, of every single piece of paper you file. Okay, and this part is incredibly important, so please listen closely. This explainer and the playbook it comes from are for educational use only. This is not legal advice. Every single case is unique, and the laws are different from state to state. You should always consult with a licensed attorney in your area about your specific situation. And that's our breakdown. But I want to leave you with a question, something to get you thinking and hopefully feeling a little more empowered. Based on what you've learned today, what is one thing, just one thing, you can research to better understand your rights and the specific options available to you in your own case? Because knowledge really is the first step.